Good morning, everyone. It is September 12th, 2023, and this is the Law and Policy Committee meeting of the California Fair Political Practices Commission. Ms. Contreras, would you please call the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. We'll begin with item 1, public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none. Proceed to item 2, approval of the June 2023 committee minutes. Commissioner Baker, any edits or comments on the minutes?
No, thank you. Move to approve.
I will second. Is there any public comment on item 2? Hearing and seeing none. Ms. Contreras.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
Motion passes.
All right. Moving to item 3. This is a presentation by our General Counsel, Mr. Bainbridge, on candidate-controlled ballot measure committees. This was requested by Commissioner Baker some time ago.
Thank you.
Take it away, Mr. Bainbridge.
I was just saying my 8-year-old picked out the style of the slides, so she's very excited that her slides she picked out will be on YouTube this morning. Has a much better aesthetic eye than I do. These would have been black and white and plain if it was just me.
I thought these were very modern and reflective of the current times.
Yeah, I didn't want everyone to be distracted by the fact that I did this, so I thought I'd get that out there.
Thank you.
So this presentation comes about, there was an enforcement case that the commission approved a settlement back in March, and there were some questions amongst the commissioners, particularly Commissioner Baker, about candidate-controlled ballot measure committees, what the law is. The case that kind of spurred this had involved a candidate for governor using ballot measure funds for a committee he controlled to promote himself in his candidacy for governor. So that's the backdrop for this. So my presentation here gives a very basic outline of what these committees are and what our rules are and a little bit of the history of them. And then from there, we can go wherever we want to. Originally, we're going to come back to the commission with this. We decided to bring it to Law and Policy and then see if it was then something we wanted to bring to the commission later. So I'll go through this. If you want to stop me in the middle, you can, or you can wait till the end, however we want to do it. Okay, so we'll start with what is a ballot measure committee. There's two types. There is what's called primarily formed, and then there are general purpose. Both are ballot measure committees. Both are defined by statute. The main difference is a primarily formed ballot measure committee typically concerns just one measure and doesn't last for more than that election cycle, whereas a general purpose ballot measure committee often supports more than one ballot measure and is more likely to be an ongoing entity as opposed to one that's around for one measure for one election. The one exception to that would be that primarily formed can include multiple ballot measures if they're for the same election in the same jurisdiction. So you may have a no on 4, yes on 5 type deal where the ballot measure could be primarily formed for both of those if it's same election, same ballot. We have regulations that define when a committee becomes primarily formed. There's what's typically known as the 70% threshold. So if a committee spends 70% or more of its expenditures on one particular ballot measure over a certain period of time, it will qualify as primarily formed. There had been arguments in the past that any expenditure outside of the particular ballot measure would qualify it as a general purpose as opposed to a primarily formed. But we adopted regs 12, 14 years ago that set up the process for determining when a committee, because a committee can go from a primarily formed to a general purpose and then back to a primarily formed. So that's something people with these committees have to watch out for and keep track of how much they're spending on particular measures.
Sorry, can I ask a question? What's the look-back period for determining 70-30?
I don't remember. Do you remember? 24 months.
Okay, thanks.
And the rules are a little bit different depending on what type of ballot measure committee we're talking about. So we'll talk about that a little bit more as we go along when we get into the specific reg. Should I advance it, Ellen? Oh, there you go. Okay. Okay, so then we talked about what a ballot measure committee is. The other part of it is a controlled committee. So a controlled committee, also defined in statute, is a committee is considered controlled if a candidate has significant influence on the actions or decisions of the committee. And then a candidate is permitted to control a ballot measure committee per our regulation. We have said this. I think this is pretty common sense given the First Amendment concerns that prohibiting a candidate from controlling a ballot measure committee would likely fail First Amendment scrutiny. There's no cases directly on point, but I think for as long as I can tell, this has been accepted that this is something a candidate is allowed to do in the democratic process is have this level of influence over ballot measure committees. All right, so that's the basics, the very basics of what a candidate-controlled ballot measure committee is. And by their very nature, and the candidate-controlled ballot measure committees create certain issues and concerns, largely because they have, it's an opportunity for a large pile of money to pile up essentially in this committee, and it operates outside of the typical contribution limits that we have. So none of these are new. They've been ongoing for a long time, and the commission over the years has tried to find ways to address some of these concerns in which what is a legitimate committee could be misused by the candidate that is controlling it. I think the main concern is often the ability for a candidate to promote themselves through the ballot measure committee, which the case I talked about at the start of the presentation, I'll get into in a little more detail. It's essentially what went on there, where money from the ballot measure committee is used basically to make the candidate look good. Why is that a problem? Well, this money is supposed to be used for the ballot measure, and as we'll see, it comes in without any limits. So if a candidate can use it to promote themselves, it's a pretty easy way around contribution limits. Other concerns that have been expressed over the years that the ballot measure committees can be used to create a war chest for purposes such as supporting other candidates or issue ads or just some other purpose that is not related to a ballot measure. They also could be used to defray costs for a candidate. So, maybe a candidate has a consultant that gets paid very little to be a candidate consultant, but gets paid a lot to be a ballot measure consultant. Those sort of instances, and then there's just the practical confusion that comes about if people aren't aware that something is a ballot measure committee. It can be hard to tell who's spending what money at times, it can create confusion as to what the ballot measure committee is and what it exists for. So with these concerns in mind, the commission over the years has tried to come up with ways to address these. Back after Prop 34 passed and contribution limits became the permanent law of the land, the commission attempted to apply the candidate contribution limits from Prop 34 to ballot measure committees by essentially saying contributions to a candidate-controlled ballot measure committee are considered contributions to that candidate for purposes of limits. The appellate court in California struck that down. The court found that that regulation directly conflicted with sections of the act that had been put in place by Prop 34, which placed limits on contributions to candidates and said there were no limits on other contributions except those to candidates. The court concluded in looking at the various statutes in the act that the contributions to the ballot measure committee are not contributions to the candidate. So by the commission adopting a regulation that said these contributions to these ballot measure committees are limited, it was in direct conflict with the provisions of the act, which provide that only contributions to candidates will be limited under Prop 34. So because of this direct conflict where the court determined that the regulation of the FPPC was in direct conflict with what the statute said, the court did not give the typical deference that it would give in evaluating regulations that an administrative agency adopts. Typically, the standard when a regulation is adopted by an administrative agency to effectuate a purpose of a statute is one of reasonableness. So as long as the regulation is reasonable, a court is not going to substitute its judgment for the judgment of the agency which has been given the authority to interpret the laws. In this case, the court said that's not what we're doing here. What we have here is a direct conflict between what the legislature has said and what the commission has said, in which case there is no deference given, and we determine what the law requires, and your regulation is in conflict with the law. So that was the background of the first attempt to limit contributions. So after that case, the commission, a couple years later, adopted Regulation 18521.5, which is what we have in the law today. This time, instead of trying to impose limits, which the court had already said conflicted with the law, the commission aimed at attempting to apply the provisions of the law and put additional rules in place to further the purposes of both the contribution limit rules from Prop 34, as well as the trust that's put in place for contributions to campaign committees, meaning monies that are given to a committee are for the purposes of that committee. And that's both in the Act as well as in the Elections Code as it relates to ballot measure committees. Money given to them should be used for the purpose for which the committee exists, which for ballot measure committees would be the specific ballot measures which they've identified as being their priorities.
Mr. Bainbridge?
Yeah.
You might be about to go into more detail on that very point. What are some of the, either here or at the appropriate time, what are some of the fact issues or principles that the FPPC looks at to determine that expenditures were in accordance with this? Like, how broadly do you look at that? And what might be an example of going outside of permissible use of funds?
Yeah, that's probably, we'll get to that over the next couple slides.
Okay.
And I'll give some examples from enforcement cases, and then if we need more, we'll go from there.
Thank you.
Okay. So I have these little graphics here that show sort of the four main parameters that were put in place by this regulation to ensure that essentially the whole goal of all of them overall is to make sure funds given for ballot measures are spent on ballot measures. So the most important one is establishing a rule for what is permissible use of funds. There's also a clarification because under statute there is one limit that does apply to ballot measure committees. So we'll talk about that one briefly. It's very confusing and rarely I think is an issue, but it's there. They also, in the regulation, it requires that the committee clearly identify the candidate that's associated with the committee through its naming, and then also to identify the measures for which it exists to support or oppose. And that's on their statement of organization. And then there's also some additional disclosure and record-keeping rules that really are aimed at making it easier to trace money and ensure or determine exactly how expenditures that are made, which ballot measure they're related to. I think it allows both the public and people who work here at FTB to be able to trace and understand when a committee changes from primarily formed to general purpose and exactly how the committee is spending its money and on which ballot measures it spends its money. All right, so the first and probably most important rule from the reg, although it's subdivision D, I put it at the top because I think it's the real crux of it, is that committee funds can only be used for expenditures related to a state or local measure or for qualification of such measures. So there has to be a pretty clear connection between what the money is being spent on and a measure for which it's being spent on. You'll remember we had the case of the joint Travis Allen to repeal the gas tax ballot measure that came before the commission in March. In that case, the candidate for governor had this ballot measure, this candidate-controlled ballot measure, and it ran an ad that identified him as a candidate for governor. He stated it, and then they also ran a graphic. And what the rest of the commercial was about the gas tax and repealing the gas tax. But it was done in such a way that enforcement, I think, rightly determined that it wasn't just to promote the measure, it was also being used to promote the candidate for office. So the portion of the ad which was supporting the candidate for office was not a permissible expenditure under this provision because it was not related to the ballot measure. And so that was an improper expenditure, and that's what the Enforcement Division found and what the commission approved in adopting the stipulation. The other case, and this regulation went into effect in 2009, and we could only find two cases, enforcement cases involving it. The other one involved former Governor Schwarzenegger. A little bit different scenario, but same provision, which is instead of using ballot measure funds to support himself or promote himself, it was to promote an issue, which at the time was the budget. He had used the ballot measure committee funds to run ads essentially attacking the legislature, which was insisting on certain budgetary provisions, which the administration disagreed with. But the budget battle and the issue ads that he ran using those funds, the commission determined was not related to the purpose or a ballot measure that the ballot measure committee would have been supporting. So those are the two instances where the commission has found that funds that were not being used for ballot measures. I don't know if, a lot of it's sort of a case-by-case basis where you have to look at, well, how are you using these? Would this be related to a ballot measure? Would it not be? I think in both those cases, the commission was pretty strict in its interpretation, and again, I think rightly so, that those expenditures were not clearly related to a ballot measure, and therefore these funds couldn't be used for those sort of expenditures.
Can I ask a question?
Yeah.
So just kind of teeing off of one of these with a slight twist on the facts. So suppose that a candidate has a candidate-controlled ballot measure committee, and they are also running for office in the same election cycle. And they have an ad in which they are featured, and the ad, 1 or 2 minutes of the ad talk about themselves and show images of them, and the remainder of the ad talk about the ballot measure committee. Is it permissible under the regulations to prorate the expenditure between the ballot measure committee and the campaign committee to avoid a violation?
The regulations don't speak to that. I haven't seen that scenario come up, so I'm hesitant to speculate. I think it's a good question. There are other instances where, so if you have two candidates who want to do an ad, they can split the cost of the ad. We will see that. So it could be analogous to that sort of situation, but I don't have a definite answer for you on that one.
All right. And what about so using the Schwarzenegger example, I mean, it seems to me that one seems very straightforward, right? There was no ballot measure at all, so I don't know what the argument would have been to use ballot measure money. Mm-hmm. But had there been a ballot measure that then Governor Schwarzenegger was promoting related to, let's say, reforming the budget process, would that have been permissible to talk about something going on in the legislature as a justification for why you are supporting and proposing an actual ballot measure?
Yeah, I mean, I think generally, yes. Obviously, it would depend on how it's phrased and sort of all the surrounding circumstances. But if there actually is a ballot measure and the ad is germane to supporting that ballot measure or opposing another ballot measure, it would be permissible. It's all very fact specific, and like with the Allen case, it's sort of a cumulative. Mr. Burton had talked about that and discussed it with the commission, that maybe one of these things wouldn't be enough for them to have concluded that it was impermissible use, but there's a cumulative effect that, okay, at a certain point, you're clearly promoting the candidate as opposed to just promoting the ballot measure.
And then, so, because we're talking about permissible use of the funds, as I recall, you are not permitted to use candidate-controlled ballot measure funds to contribute to other candidates. Is that correct?
Yes, that is a definite no-go.
All right, so that's a definite no-go. And at termination, if you have a surplus, are there restrictions on, let's say you want to give it to the party that you're a member of? That goes over to the party in a restricted fashion as well, prohibiting them from then using it to support candidates, right?
Yes, that's right. It's in the regulation, that this 18521.5 was one of the provisions to ensure that these funds could not go to candidates. So a committee is restricted in using it to relate to a ballot measure, except when the committee is closing. One of the exceptions is it can go to to the party committee, but the party committee has to keep it in its restricted funds, not to be used for candidate support.
Yeah, so I'm asking this because I'm just curious as we sit here today, one of the concerns going back a few slides that you identified were that these committees could be used to build war chests for purposes of supporting other candidates. But it sounds like we actually have already anticipated that and cut that possibility off. I just wanted to make sure I understood that correctly.
Yeah, that's right. I probably should have clarified that. That slide are sort of the historical concerns with the ballot measure committees, and then this regulation has attempted to largely address those concerns.
Okay, all right, thank you.
Excuse me, I have a whole bunch too, but I'm going to start with that last one. Regarding not directly supporting a candidate, could they, because if that candidate has a ballot measure committee, could one ballot measure committee contribute to another?
Yes.
And then that candidate can control that
let
ballot
me-
measure committee?
I said yes too soon. I'd have to look at that, because
Okay.
if you're going to a different ballot measure committee, you're not supporting the ballot measure for which you've raised the funds, so that may not be permissible. I'd have to double check on that.
And the same question would go to surplus. So if the regulation only allows, and I'm not sure if it's statute or regulation, that only allows surplus funds to go to a party committee, or if the surplus funds can go to another ballot measure, maybe there's another, for example, I might have one on housing, and, I decide I'm terminating that, and I'm going to send it over to another one that's on housing, that might fight the same cause purportedly. And could I do that, either pre-surplus or surplus? And if you need to get back to us on that, I can understand.
So it essentially makes them surplus. The two things you can do, other than support the ballot measure for which the committee was formed, is once they're surplus, they can go to a party
Okay.
with restricted funds, or they can be treated as surplus funds, which I need to cross-reference here.
You mean the general, the same surplus funds that candidate committees' surplus funds are limited to being if they become surplus? Yeah. Yeah, I think you can do charity, education, or something.
Right, yeah, it is the general surplus funds provision. So, right, charitable contributions to political party committee, yeah.
Okay. So the chair's question got to one I was heading for, and this now seems like a good spot for it, and that is, does there have to be a ballot measure? What does that mean? So if I, for example, were to set up a committee that is on housing, I want to support, Californians for housing, but I haven't qualified one, I'm not, I'm not undertaking efforts to get signatures. I'm maybe not doing expenditures to convince legislators to put that on the ballot. But so there isn't like a qualified ballot measure that has, met the signature threshold, is going to end up on a March or November ballot. But so can you address a little bit more what it means to support a ballot measure when there is or isn't one actually qualified yet?
Sure, and it can be qualified or not yet qualified. Obviously, it takes money to qualify a ballot measure in the first place. So if they couldn't open a committee until after a ballot measure had qualified, it may be very difficult to get the measure qualified in the first place. But there's an expectation that there's a specific topic or idea in mind, and that the committee in opening is working towards qualifying a ballot measure.
Okay, that's an expectation in practice, or is there anything in the language in the reg that, I can see here what it mentions, but is there anything, any more expectation that is put in there? For example, in other areas where funds can only be spent on a particular purpose, and if you use certain magic words, it's more than an expectation. It's spelled out a little bit more. Is there anything more like that in the regulations?
What there is in the statement of organization, they must describe the purpose of the anticipated measure. There's nothing beyond that. You're signing a statement of organization under penalty of perjury, and you're saying I'm intending, or I'm describing an anticipated measure. But beyond that, there isn't any sort of, I don't know, promise to open this committee. There's no timing requirement in which a measure has to be qualified.
Okay, that went to another question of mine, which was the timing, because I think at the beginning, you mentioned that primarily controlled committee, let me get my terms right here. Yes, primarily formed ballot measure committee doesn't last more than that cycle. But,
Generally.
Okay.
It's not necessarily true. You can redesignate. A committee can go from primarily formed to general purpose and back and forth.
okay,
But generally, primarily formed is created to support a particular measure. After that election, they'll wind down the committee.
okay. Are there requirements that it has to be, for example, when you're Catherine Baker for Assembly, that's not what I can entitle my committee. I have to be Catherine Baker for Assembly 2050. And I have to list a year, and I better put it in all my stuff. If you drop the year off, you're actually not doing it right. Is it similar with respect to ballot committees? That Catherine Baker for Housing, or, Californians for Housing 2024?
The candidate has to be identified that's controlling the ballot measure committee on the naming of the committee.
see.
And then once the ballot measure qualifies, then the name of the ballot measure has to be included in the name of the committee.
Okay, so that's just in the name, which then has to be on all the disclosures, presumably. Okay.
It doesn't state the year, but it'll state, Measure M.
So an individual, someone who's in office and probably has a candidate committee, can open up a Catherine Baker for Housing committee? Or maybe I should use you as the person, just to keep it clean. But
No, keep going.
or Jay when he's not at his sandwich shop. But let's say it's Jay. Wairenga has for Assembly, and he's also got this housing committee. He can be raising funds, very sorry, and expending them on maybe talking about housing policy, or does he have to get more specific and land on, we need to change the housing policy? I'm moving into that question next.
Yes, that he could open the committee, as you
Okay.
described. As to how specific his early communications need to be, that's a little too speculative. I
Gotcha.
wouldn't want to get into that.
Okay.
But it should be working towards a ballot measure committee,
Got it.
Kessler,
qualifying a ballot measure committee.
Very quick.
Go ahead.
Just clarifying question.
Yep.
Primarily formed, the designation as being primarily formed. Does that only occur after a measure has, is there a moment in time in which somebody, a committee, has to go from being general purpose to primarily formed? Or could they be primarily formed from day one just because they, in their minds, are focused on one issue, even before there's actually a ballot measure?
Yeah, if the intent is to be focused on one measure, they should form as primarily formed from the beginning.
And the last one I had for this moment that we're at, going to the question of, the Travis Allen and Arnold Schwarzenegger cases, I think you've mentioned, and it makes sense, that any one of those factors that was looked at in both of those comparables wouldn't necessarily take it into unpermissible expenditure, but it's kind of a combination. That said, if you mention that you're a candidate, let's say I'm Jay, I'm an Assembly member, and I'm also running this ballot measure committee. I'm Jay, running for governor, and I think we should do housing policy as a priority and pass this housing measure. Or if they don't mention at all they're a candidate, but they do mention, I'm Jay, Assembly member. They don't mention they're running for governor. Can you address if those are two that maybe fall one way or the other? And I realize we're getting into, we're going to have, hopefully not, but prior other cases coming forward. I wouldn't want to hold you to it. But that's one of those lines, is mentioning that you're a candidate versus that you're currently someone in office, if that tends to tip things in the scale.
In my mind, it does. If I was in charge of whether to bring a case in that sort of circumstance, I would say someone mentioning themselves as a candidate for office is very strong indication that they are not just stating that for purposes of supporting the ballot measure.
Okay, I think that's the Travis Allen example that we had, or maybe it was also Schwarzenegger, but, okay. Thank you. That is it for this point.
Okay. All right, so that's the limitation on permissible uses. Here's the very confusing limits that do apply to ballot measure committees. So 85310 has a provision, and it's often thought of as an electioneering provision, which is when there's an expenditure by a committee of $50,000 or more for a communication that features the elected official within 45 days of an election, that has to be disclosed. Now you'd say, well, isn't that a campaign advertisement? This would be a situation where there was no express advocacy, but the official is simply featured in the communication. And this provision says, just within this narrow time frame and when enough money is spent on this communication, there are disclosure requirements under the Act. Under Prop 34, it also brings in limits in that situation. So the entity that is making, if it's a committee that has made this expenditure at the behest of the candidate that is featured in the ad, that entity is going to be subject to the limit that is applied to political parties and general purpose committees who make expenditures on behalf of candidates, which is a limit on how much money the party or the committee can receive from an individual donor and then spend on candidate support. So this is simply a restatement of what is in the statute. It's just in the regulation for purposes of clarification that in very narrow instances, this limitation would apply to a candidate-controlled ballot measure committee, just as it would to any other committee that is spending large amounts of money supporting candidates.
Can you illustrate that one with a hypothetical, for example, so that within a certain amount of time, the party can only give, it used to be 36, or raise 36,000 or something. I might be confusing my numbers.
Yeah.
I do love an illustration.
Okay, let's see if I can do this. So say we have a candidate-controlled ballot measure committee, and that the candidate controlling it runs an ad, directs the committee, the ballot measure committee, to run an ad that costs over $50,000 that features this elected official within 45 days of an election. That would be a reportable expenditure on a separate form that gets reported. And it would then make this ballot measure committee subject to the limits that political parties are limited to, which means contributions to the ballot measure committee couldn't exceed I forget what the limit is, we'll say 36,000 for the political party committee limitations. They could only give that much to the ballot measure committee to be used for candidate support. Any other contributions above that amount would have to be used, restricted account for, not for candidate support. So I think the scenario this is considering is a donor gives a large amount beyond the $36,000 contribution limit to a ballot measure committee so it can run an ad that features the candidate that controls the ballot measure committee.
The expenditure of greater than 50,000 that triggers the additional report. Does that is a conditional, essentially like an earmarked contribution? It's like, I'm giving you 50,000 plus, but you have to run an ad featuring the official, or could it be any contribution above that amount?
No, this wouldn't be the contribution. This would be the actual expenditure by the committee. So this would be the cost of running. If the ballot measure committee gets, say, a $100,000 contribution,
Yeah.
and then runs an ad that costs 50,000 or more, that's when this rule is triggered.
Okay. Is it one singular contribution from which the expenditure is made, or do you aggregate it?
I don't remember if it's, I'm going to assume it's aggregated, but I don't remember for sure.
Okay, I was just curious.
And if I can follow up on that, so how do you tie the $100,000 contribution to that expenditure? Because the way I heard it is that the candidate, the behesting, is not that the candidate asked for the $100,000 to go to the ballot committee. It's that the candidate says, ballot committee, I want you to do this ad. It's going to feature me. It's 45 days, and I'm an elected. Or, I'm an elected. how do you tie that to I get that the expenditure has to be reported on a form, but how is that tied to a contribution and then anything above, we'll say for here, 36,000, from that contribution has to go into a separate, has to be segregated somehow? How does it get tied to a particular contribution?
It doesn't get tied to a particular contribution. It's just, this then triggers that contribution limit rule.
For anybody to the ballot committee?
Right.
From the 45-day, only during the 45-day period?
Right.
So you want to, if you're, thinking this through, and you're that candidate behesting the committee, you want to make that ask before the 45-day period hits. Is that right? If you want to be able to get more than 36,000 from someone to your ballot committee, you're going to ask that before 45 days. If you're,
Okay, I see what you're saying. I don't know the answer to your question about timing.
Okay.
Of whether you would look back and apply the requirements for segregating the funds into different funds out before the fact or not.
But what
It's
you do
just
know
not-
is during the 45, once it's triggered, this whole set of events, anybody contributing to that ballot committee can't give more than 36. We're using that number hypothetically.
Right.
Okay.
Well, the money can't be used for candidate support. They could give however much they want. It just couldn't be used for candidate support.
Beyond 36,000
Right.
or at all?
Beyond 36,000.
Got it? I got it.
But
Looking at
then you run into the issue of you can't be supporting candidates with it to begin with. So it's kind of a circular rule, and it's why I hesitated to even get into it, because you don't ever actually see it in practice.
You don't? Oh, that's interesting. They just don't want to play that close to the fire? or-
Well, they've already violated, if you're actually using money, then you're right, you don't want to play that close to the fire. You're getting close to supporting a candidate to begin with if you're featuring, just by featuring the candidate in the ad, you're running into the issue with making expenditures that could be considered supporting the candidate to begin with.
So you don't see this very much. Interesting. Okay, thanks.
When we're talking about candidate, well, actually, I'm sorry, I'm looking close at your slide. You say for a communication featuring an elected official. So it's not necessarily somebody who is on the ballot that election cycle. It could be an incumbent who isn't up for election during the same election cycle as the ballot measure, right?
Right, it's featuring any elected official.
Okay, so under this, just so I'm totally clear, you're saying that a candidate who controls a ballot measure committee, if that candidate-controlled ballot measure committee expends $50,000 or more for a communication featuring the person who is controlling the committee within 45 days of the election for the ballot measure, that's what triggers the contribution limit going forward to the ballot measure committee.
Right.
Okay, all right.
Okay.
And last wrinkle here. If they're not an elected official, and if they're not elected, but they're candidates. So Jay is now running for assembly. He's got a candidate-controlled committee, and he's doing, all these other things fell into place, but he's not a sitting elected official. Does that trigger any change to this?
I'm looking at the specific, I believe the language is elected official, in which case it would not include candidates.
Still may be rare because you're getting awfully close to supporting a candidate at that point, but I'm curious if that's a difference here.
Yeah, well, to that point, I'd be curious to know why that distinction was drawn, when it seems like the harm is essentially the same. You're using ballot measure committee to promote somebody's candidacy, whether it's a sitting elected or somebody who hasn't been.
I would just say, this section was not intended necessarily. They tacked on the issue with ballot measure committees, but it was intended to address electioneering. So they didn't necessarily have the ballot measure committee scenario in mind. It was more, using,
Promoting someone.
right.
Because the harm could also, and maybe there's that, but there's also possibility that a sitting elected might be more likely to start a ballot committee because they've already have their maximum contributions to their one committee and they're in office and they have the ability, I'm sorry to sound so cynical today, to, get more contributions that they can control.
And it does say
yeah.
candidate for elective state office.
Okay.
So I think in trying to shorthand this, and
Got
make
it.
it make sense in this context, I put elected official, but it's candidate, which includes both actual candidates and people who are elected officials.
All right, cool, thank you.
Okay, I think the other major provision besides the limitations on the use of funds is some of these ID requirements. So the committee's name must include the controlling candidate's last name and expressly state that it's a ballot measure committee. Again, this is rules that have been put in place by the commission to help identify ballot measure committees. And then for every measure on which a committee has spent $50,000 or more or anticipates spending $50,000 or more during an election cycle, they must include that on the statement of organization, just to make it very clear which measures the committee is connected to. And then the last set of requirements we see in the regulation are some additional disclosure and reporting requirements. And these both just apply to general purpose ballot measure committees. And what they do is require additional disclosure on campaign statements, identifying specifically what measure an expenditure is related to. And then also in the record keeping requirements, the committee is required to make notations regarding each expenditure and which measure it is related to. So this allows people to see exactly how much is being spent for each measure when you're reviewing the campaign statements. It allows you to do the determination if a general purpose committee has become primarily formed, which can have different ad disclosure requirements, and is useful also for people who are auditing or investigating these sort of issues because they have to identify exactly what each expenditure, which measure it was related to. This is the sort of thing that can be difficult if you're reading a campaign statement and you see, say, print shop, expenditures for print shops or expenditures for radio ads. They may not necessarily indicate which measure they're related to. So this requirement within the regulation requires that there be a notation in the campaign reports so that you can trace each expenditure to whichever measure it's supporting or opposing. So those are the basic requirements that we have in 18521.5 that designed to rein in the natural issues that present themselves with ballot measure committees that are controlled by candidates. I'll take any more questions. That's the end of my slides.
Commissioner Baker.
I do have some there on different topics, so, yeah. So I'd like to go back. Now we've got this great briefing, so thank you for the fundamentals. On the issue of whether you're a primarily formed ballot committee versus a general purpose committee, there's been conversation here about you become back and forth. You're switching back and forth. And can you elaborate a little bit more on what that looks like? Now, I understand from the chair's good question that there's a look-back period of 24 months. So what does that mean? That if I were to start a primarily formed ballot measure committee, so, well, I'm going to use J for housing for California, and for the next 24 months, how I've spent my time, if it's 70% on that housing thing, it's fine, I've done the same thing. But if I spend less than 70%, and I spend it on something else, that doesn't make me a non-primarily. So can you address that first situation? How you bump out of that in a 24-month period?
Yeah.
Bump out of being a primary form to maybe the general. And then I could kind of imagine the scenario where you go back the other way, but let's address that one first.
182475.
I'm pulling up the reg because it's
Step by step.
it's a pretty complicated, but not complicated, but you go through the process and there's various ways that a committee can qualify as primarily formed. Mm-hmm. I mentioned the 70% rule because that's the basic rule. There's one, I believe it's essentially based on, what your principal purpose is.
Okay.
So it's not strictly just the 70% rule, but that's usually the one we see. I think the common scenario is it's more likely that you see a general purpose ballot measure committee or even just a general purpose committee that gets very interested in a particular measure in a particular jurisdiction. And then during a certain period will spend all of its money on that measure. And why it matters typically is where things get filed. So even today in 2023, city committees filings for city committees are supposed to be done at the city level. and people may go look for campaign forms at the city clerk's office. Now, if it's a statewide general purpose committee previously, it may not be filing those local statements. But if it does meet the threshold and qualify, say it's trying to support a measure in a particular city, people looking for those forms either online with the city clerk or actually at the city clerk's office, it's important to keep track of when this designation changes, because then you know where to find the statements. And then that's this major scenario where I've seen a distinction. There's also some advertising disclosure rules that are different depending on whether you're primarily formed or a general purpose committee.
Okay.
And the committee naming requirements can be different. If you're primarily formed, you have to identify the specific measure in your name, whereas general purpose you don't, because you don't have just one specific measure. So what it requires generally, and we could another time when I'm more prepared go through this regulation piece by piece and look at specific scenarios, but generally it requires the committees that are getting somewhere near that 70% line or are diversifying in what they're participating in to keep pretty close track of how they're spending their money and which measures they're working on. If you have multiple measures, you don't have too much concern if you're spending on different measures in a pretty large amount. But it's usually when a committee is formed for one purpose and gets interested in another one as it goes along that this becomes an issue.
And then, so that's the first question. Another one is, what type of auditing, are they on the same, I should probably know this because we've had great reports and training and informational sessions on auditing. What type of, refresh this commissioner's recollection on what type of auditing happens if there's how they do the draw for ballot committees, primarily formed or general purpose?
Yeah, I don't remember the specifics.
Okay. But they're on a similarly, I'm sure there's randomized somehow, but
Ballot measure committees are not distinct. So they're either general purpose or primarily formed. They're not categorized as ballot measure committees under the audit rules. So they would be the same as if they were general purpose or primarily formed,
okay.
which is in the statute.
So just to refresh, I think this is right. So we do a draw, identify those committees, transmit the committees that were selected in the draw, it's like every 2 years, to the franchise tax board, correct? And so the responsibility to do the audits of candidate-controlled ballot measure committees that are selected for audit would fall on FTB.
Yes.
I know they have not been doing the lobbying audits as required by the act. I think I remember from the testimony before the Senate Oversight Committee that they weren't actually doing other types of audits as well. Is that true?
Right. I believe their testimony at that hearing said they were doing 20 to 50% of the rest of their audit draws.
Right. So that includes candidate-controlled ballot measure committees. So
General
the
purpose and
auditing-
primarily formed committees, yes.
Is reality, the auditing of those
Not
committees
really
is
happening.
probably minimal and contrary to what the act requires.
Gotcha. Thank you. Next question is, do you have a sense of, well, I'll take a step back. Reason I asked for this to be on the agenda for us to get a briefing on was both for my own purposes as a commissioner understanding better, but because of what is considered a common informal practice among some folks who, when they're in office, and that is they're encouraged to open up a ballot committee as an extra source of funds to both raise from people that you've already received maximum contributions to your candidate committee. I'm not saying anything you haven't already said, but then you have funds that you can use in a lot of ways still to maybe reimburse you for travel where you might go talk about housing while you also happen to be doing other things. Or for consultant costs, all the things you pointed out where there's some issue. I never had one when I was in the legislature. I didn't have a ballot measure committee. I don't disparage my colleagues who did, sure, there's lots of on the up and up part, but it is an encouragement. So I'm looking here for the abuse and the areas where it allows a loophole where someone has no good faith intent to ever bring a housing measure or any ballot measure, and they might meet the bare requirements, but it's basically become an extra fund for both fundraising as well as the expenditures to promote oneself in some way. Where I'm going with this is, with that, cynical background that I don't personally have, but I know is out there, do you have a sense of how prominent these committees are that never become a real ballot measure, that never mature? Either they don't eventually terminate because in a particular cycle they just didn't get there or whatever, or they have no indicia of ever landing a ballot measure, but it's used.
I think my sense would be based a lot on a lot of the same things you've seen and read, that they're out there. And there's really nothing, they're going to exist, and there's not much that can be done about them, as I mentioned, because of the First Amendment restrictions. My sense is that the regulation that the commission adopted in 2009 has done a pretty good job, given what could be done, to address the obvious avenues for abuse. And I think by strictly enforcing the rule that the expenditures need to be related to a ballot measure, and you got to say which ballot measure, I think the rules that we have are pretty good in preventing the money being used in ways that shouldn't be permitted. There's not really any way to stop the fundraising, again, because of the First Amendment concerns, but I think the way the regs that we have done a pretty good job of then restricting misuse of the funds that once they've been raised. And I would say my sense of that is based largely on the fact that we've had 2 enforcement cases during that time. And if there was misuse going on, it'd be pretty easy to spot. And I think there's always someone interested in someone else's campaign filings, and they could point this all out because it should all get reported.
If I may, great analysis. I guess I would add to that since virtually no auditing is going on, it brings a little less faith that where there is potential abuse, it would basically have to be found by maybe an opponent to something who has the time and resources and sophistication themselves to do this, as opposed to a real forensic audit. So I have that faith, but at the same time, I know that there's practical things that are not happening. And it does kind of presume that, you can open a committee with no time frame for fishing or cutting bait. Like even the time frame that if you don't actually qualify a measure within 4 years, you have to terminate the committee and transfer it to a new one. Something that's built into the system to just sort of start it over. I bet that would require a statutory change, which is my next question. And that is, are there either regulation or statutory changes that, as you've done this look back and heard the feedback we had both earlier this year and in our 2-person conversation here, that might be possible improvements?
I don't have any in mind. I think we are largely constrained by constitutional principles. I think the regulations are pretty good in my experience studying them. It might be interesting to talk to some people in enforcement, but again, there's only been 2 cases.
Yeah.
So there's just limited experience with them, and I don't have. I think you mentioned statutory change, and I think you also would have to consider any statutory change is probably going to end up in court before it gets put in place. If it's going to make real changes, significant changes to someone's ability to have a ballot measure committee, I think that's another consideration. So I don't have any great ideas, is basically.
You often have great ideas. The only ones that have come to mind as I'm learning more now in these rules is if there may not be an appetite for it. I think it'd be very hard to pass. I'm not sure we would all support it, but a contribution limit on what you can give to them. That would have to require statutory change because it sounds like that didn't work out regulation-wise.
Well, part of the story here, though, it didn't begin with the Citizens case, right? It actually began back in the 80s at the Supreme Court when the Supreme Court ruled in the Berkeley case that you could not impose contribution limits on ballot measure committees.
Really?
So we're not writing on a blank slate here by any stretch of the imagination. And it's been the law of the land for almost 40 some odd years now that you can't limit contributions to ballot measure committees.
And that was an issue in the Citizens to Save California case. The court never reached it because they could decide it on the statutory grounds. So The ballot measure committee case that the chair referred to didn't concern a candidate-controlled ballot measure, but you essentially have to determine that the fact that it's controlled by a candidate makes enough of a difference that there's a compelling interest to prohibit or limit contributions to a ballot measure committee.
I'm having flashbacks to our conversation about the recall, because there was some conversation there about why a recall is or is not a ballot measure, which then has no contribution limits. I won't require us to revisit that here, but that did pop up in my mind. Thank you for the reminder. And the other one is what I last referenced, and I just have to think about it myself, if this is an improvement and if it's a good improvement that then could be enacted, and that is that there's a time frame by which, if you, let's say you're somebody who has termed out of office and you want to stay out in the world and doing things, and you decide, well, I'm going to open up a ballot measure committee, either general or primarily formed, and I use that to keep my donor network going, to keep me out there and above the public, or I should say keep Jay out above the public, but never, like 10 years goes by, and you never land on a ballot measure. If there is any appetite, or is it appropriate to have a time frame? Maybe it's a 4-year cycle. I just don't know, but that's one area I'm going to be thinking about, and I would invite your feedback as well as the chairs, if that's something that would be an improvement, really to be getting at those scenarios where there's no good faith intent to ever mature to a ballot measure. It is to have some additional funds to raise and use politically, even within the constraints that are provided, knowing that nobody's actually, not nobody, but very few audits are happening. So that's my sentiments at the time. Welcome feedback.
Do we have any data today? How many candidate-controlled ballot measure committees are open, for how long they've been open, that we could test kind of the hypothesis against? Is this something that is frequently used? Is this something that we have a circumstance in which these committees are open and then never fully mature? Or is it something that happens infrequently, but, is brought to our attention rightfully so? I mean, it would seem to me that that data exists in the Secretary of State's records, and that we could run that data and provide the commission with actual data to support the hypothesis and to point to a direction of where we might want to devote our efforts. I mean, is that your sense?
I never want to speculate on the CARE system, but we can check with SOS and see if that's data that they can mine from their system.
Yeah. Because I think my preference would be, I'd like to start there. I'd like to start and see what the data shows before we commit necessarily to a path towards tightening up the timing restrictions or what have you, which I would also have some concern about from the First Amendment perspective. Although if it's just simply, closing one committee and opening another, I'd want to think about that some more. The only other thing that I would offer as a possibility here is, Mr. Bainbridge, is it within our regulatory authority to determine what the contents of the disclaimers are, or the name requirements for ballot measure committees, such that if we wanted to say it's the name of the candidate that controls them, and the ballot measure, and the year of the measure, right? And particularly, I'm thinking about committees that are open and there isn't something on the ballot, but to require the committee to identify the likely year in which they are going to run a ballot measure. Because then you're kind of putting them on notice, what is your time frame for doing this? And then,
Yeah, I'm just looking over the current regulation. I think so. I think it's similar to what's in the current regulation. I think it's relevant and serves the same purpose as some of these other requirements of ensuring that ballot measure funds are used for ballot measures.
right, at least then there's a publicly articulated end date at which the work of this committee would be anticipated to wrap up and materialize into something that the voters would be presented with, if successful through circulation.
We'll look at the primarily formed naming requirements to make sure it's not already in there.
Yeah. All right. All right.
If I may-
Commissioner Baker?
On the data point, thank you for landing it better. I would just ask you to speculate. It's much better to have the data, so it's how many and how long have they been open? And that might be something that can be aggregated, like this many have been open for 10 years, this many have been open for 2, this many have been open for 1. And I will be thinking of any other data that might be helpful, that's going to be the primary one that comes to mind. I'm trying to think of ones that, is it helpful to know when they toggle back and forth between primary and general? I'm not so sure, because that doesn't seem to be getting to the issue of opening one so you have more funds to control with no intent to do something. But I think that would be helpful information to have. Oh, I remember the other one. If it's possible, and this could have happened at the Senate Oversight Committee, if it's possible to land a little bit more information from FTB on the audit, what in maybe the last 6 years, 6 election cycles have, 3 election cycles, 6 years, have been the audit rates for either primarily formed or general purpose ballot measure committees. And this is very helpful. I appreciate how quickly you came back with this. Maybe gathering the data first before we bring it back to the full commission, because we might spare them some questions that we already will have the answers to. So, yeah.
All right. Mr. Bainbridge, any concluding thoughts on your presentation?
Nope, talked enough.
Good 8-year-old graphics.
Thank you.
Good job.
Take that as a
Future graphic
compliment.
designer.
Let me just pause for a moment and call, is there any public comment? We're on item 3. This is our presentation by General Counsel Bainbridge on candidate-controlled ballot measure committees. All right, hearing and seeing none. Thank you, Commissioner Baker. Thank you, Mr. Bainbridge. Excellent presentation. So moving to item 4, discussion of items for our next committee meeting. Let me just say, I think we're going to have our next committee meeting not in October, but in November. And that would be the meeting at which we start to have conversations about future regulatory and legislative proposals for next year.
Yep. And I appreciate that. October will be, well, after the legislature has adjourned and we've found out what's on the governor's desk and what is in the trash, but, or in a pause period. I would, in advance of the November meeting, presumably it'll be in November, this is probably a request I make every year and I do it again, and it's hopefully not too burdensome on the staff team. Throughout the year, we say, hey, this sounds like something that might be a possibility for legislation. And I don't keep track of that when I say it because I know there's a recording. And so that's the one ask I have, is a friendly reminder of what did we say as commissioners for the last year. I'm sure the team already does that as part of their diligence. And then, of course, what of our package in this last year that may have been held in approbes or couldn't find an author for that we think is real high priority, that we can begin to do that groundwork for even before they come back into session in January, the legislature. Eager to see that. So great. Thank you.
All right, any public comment on item 4? Hearing and seeing none, do we have a motion to adjourn?
Move to adjourn.
I will second. Ms. Contreras.
Commissioner Baker?
Aye.
Chair Matich?
Aye.
Motion passes.
All right, thank you, everyone. We'll see you in November.